Discrimination is socially constructed. Law is also a product of civilization, a cultural construct. Reason and the legal concept of reasonableness is based on the standard of the man and the social inequality may be the cause for unequal status and resources. If the law is applied impartially to unequals in status, power, resources, or education, it results in inequality being reinforced, not redressed. Against women, CEDAW has been used in legal jurisprudence in a number of ways. When does differentiation become discrimination? We have seen that the courts, while taking the substantive approach to legitimate expectation, verify if the change in policy is reasonable. We have seen the different approaches by courts to understanding differentiation and discrimination. How does the extensive definition of discrimination in Article 1 of the CEDAW enhance these approaches? The answer to this question is what we will be dealing with today. In the previous video, we examined the concept of reasonableness in Indian jurisprudence and the way the courts have dealt with difference in deciding when differentiation is not discrimination. In this video, we will be dealing with the opposite effect, that is, when and how differentiation leads to discrimination. We will be examining the detailed definition of discrimination in Article 1 of the CEDAW and will try to understand the different ways in which differentiation and their effects with the help of examples from the Indian legal system. The analysis of inequality starts with the recognition of the exact nature of the discrimination extent. Discrimination causes inequality. Non-discrimination is the means of achieving substantive equality. Discrimination is the action and inequality the result. The Supreme Court in Visakha versus State of Rajasthan, Valsamma Paul versus Cochin University, and Idol of Swaminatha Swami Tirukoil versus State has incorporated CEDAW into Article 14 and 21. The principle of non-discrimination in CEDAW is based on the ideological understanding that discrimination is socially constructed. Each word in Article 1 is crucial in identifying different forms of discrimination and creating various entry points for framing arguments regarding discrimination. The CEDAW provides a framework on discrimination through Article 1. Discrimination can be intentional or unintended, direct or indirect, a cause caused by past, present, or structural discrimination, an action de facto or de jure, or a resultant impact, cross-cutting or impairment or nullification of the right. This framework has been modified from CEDAW Restoring Rights to Women by Partners for Law in Development and UNIFEM 2004. Let us take a closer look at this definition, clause by clause. Elements of Article 1 of the CEDAW made on the basis of sex and gender. This is elaborated by all the clauses that come after in the definition, but a simple interpretation would be, for example, the following. Sex or gender discrimination is when someone is treated less favorably than another person because of their sex, gender identity, sexual orientation, pregnancy, or pregnancy-related condition. For example, in the case of C.B. Muttama versus Union of India, 1979, women employees in government service were required to get government permission before marriage or could be terminated citing domestic commitments as a bar to continuation. Women had no right to appointment if married. This was the subject of the challenge. Discrimination, the intention. Classification based on intent. Elements of Article 1 which has the effect of purpose. Purpose, direct discrimination. Direct discrimination is intended and apparent on the face of the record, that is prima facie. Such discrimination is apparent not only in statutory instruments such as laws and regulations, but may also extend to government policies or contracts. Section 13 of the Equality Act 2010 of the UK, direct discrimination is characterized as follows. A person A discriminates against another B if, because of a protected characteristic, A treats B less favorably than A treats or would treat others. In simple terms, direct discrimination happens when a person is treated differently because of the way they are. Effect: indirect discrimination. Discrimination will occur when an apparently neutral condition or requirement that is imposed has a discriminatory effect, although discrimination was not intended. In simple terms, indirect discrimination happens when something applies to everyone in the same way but affects some people unfairly. For example, in Australia, women retrenched from a steel mill because of the ruling last hired, first retrenched, filed a case of discrimination successfully. While it is true that the women concerned were hired last, the fact was that this mill had a discriminatory policy several years ago of not recruiting women. At that time, it was considered inappropriate for women to work in a steel mill. The women were the last to be hired, and as a consequence, they were the first to be fired. This historical discrimination acted against them, although it was unintentional. Discrimination, the action. De jure discrimination. De jure discrimination is discrimination that is enforced by law. For example, laws that separate people based on race, religion, gender, or age are de jure discrimination. Gender discrimination. Laws that prevent women from leaving the country or holding a job without their husband's consent. De jure discrimination is prima facie by written law or procedure. For example, under the Hindu Minority and Guardianship Act of 1956, although a woman may obtain full guardianship and custody of her children with the permission of the court in special circumstances, the law for Hindus recognizes only the father as the natural guardian. Discrimination, the action. De facto discrimination. De facto discrimination is when discriminatory practices continue to happen even though the law formally prohibits them. These practices can be based on race, gender, color, religion, language, and more. They can manifest in a number of ways, including unequal access to education, healthcare, employment, housing, and other resources and opportunities. Segregation, such as in public areas like bathrooms and water fountains. The term de facto comes from Latin and translates to in fact. De facto discrimination is unwritten in the law but a practice based on social norms and customs. The practice of many immigration officials in various countries is to find a woman traveling alone with her minor children suspicious, while men traveling with their children are seldom questioned. Elements of Article 1. Any distinction, exclusion, restriction. Distinction, a simple differentiation. In Burma, girls wanting to study engineering needed to obtain higher grades and meet additional requirements than boys to enter university. In the past, students were told that this was due to the fact that this was not a traditional career for women and that women have a tendency to stop practicing as engineers when they get married. Exclusion, excluding women. In A.N. Rajamma versus State of Kerala and others, women were denied appointment as last grade servants, assistants, cleaners, etc., only on the basis that they were women and therefore could not perform arduous duties. Restriction, restricting the exercise or enjoyment of a right. Protectionist laws and policies that limit women's work at night or limit their freedom of movement. For example, in Vasanta versus Union of India, Madras High Court 2001, a woman factory worker was prevented from working the night shift at the manufacturing unit by her employer since a national law prohibited women from working in the factory at night. Discrimination, the cause. Present. The discrimination is ongoing and current. In Anuj Garg versus Hotel Association of India, the law in question prohibited the employment of women in premises where intoxicating substances were consumed. The court struck down the law for violating Article 15(1) of the Constitution, noting that the legislation suffered from incurable fixation of stereotyped morality and conception of sexual role. Past. For example, in India, when a quota was introduced for women in the local body elections, both at the membership and leadership level, the husbands of women who were elected functioned as the de facto councillors, as women could not read the minutes or instructions, had never participated politically, and other men were unused to sitting with women on committees. This is the effect of past discrimination. Structural discrimination is a form of institutional discrimination that limits opportunities and rights for groups or individuals based on protected characteristics like race, gender, sexual orientation, or social class. It can be based on rules, norms, and routines in institutions and other societal structures. Politics, practices, and other norms reinforce each other, forming a system and a culture that allows privileges associated with cultural hierarchies to endure and adapt over time. Policies, practices, and other norms reinforce each other, forming a system and a culture that allows privileges associated with cultural hierarchies to endure and adapt over time. Some examples of structural discrimination include residential segregation, unfair lending practices, environmental injustice, biased policing and sentencing, and voter suppression policies. In convicting a man from a dominant caste who was accused of sexually assaulting a blind woman who was a member of a scheduled caste in Patanjaman Wali versus State of Andhra Pradesh, 2021, the Supreme Court held that the provisions for rape under the Indian Penal Code 1860 IPC allowed principles of intersectionality to be applied when deciding the sentence, and proceeded to convict the accused under the IPC and sentenced him to life imprisonment. Cross-cutting discrimination. The Vienna Declaration and Programme of Action of the World Conference on Human Rights states that all human rights are universal, indivisible, interdependent, and interrelated. Thus, a discrimination experienced by a person in one field affects her rights and opportunities in other fields. Discrimination and access to education results in the lack of access to decision making in the area of public policy, as we have seen in the case of the Panchayat elections quotas for women. Impairing, nullifying recognition. Where a right doesn't exist, acceptance or acknowledgement. Impairing, restricting or modifying. An Indian bank would not recognize the mother as the guardian of a minor child because national legislation stated that a mother could function as guardian only if the father was dead. Geeta Hariharan versus Reserve Bank of India, 1999. Nullifying, making completely ineffective. Nullifying recognition. In many countries, following a shift from the uniform civil codes to religious personal laws and changes in governments, women have lost rights. For example, in Afghanistan during the Taliban regime, women have lost the right to freedom of movement, the right to be protected from discrimination in employment and work, among others. Continuing with discrimination, the result. Impairing or nullifying the recognition, enjoyment or exercise, elements of Article 1. Impairing or nullifying exercise. An advertisement for the post of nurse required married women to obtain a letter of consent from the husband. The court held the requirement to be discriminatory under the equal opportunity provision of the Constitution of India, Maya versus State of Maharashtra and others, 1986. Nullifying exercise. Impairing means to prevent the exercise. Nullifying means to completely not even recognize the right to exercise. The petitioner PIL challenged certain provisions of the Chota Nagpur Tenancy Act 1908, a law relating to land tenancy and the settlement of rent in Chota Nagpur, Bihar, the petition was filed on the premise that this is discriminatory against women. The court decided that the exclusive right of males must be suspended so long as the right of livelihood of the female descendant of the last male holder continues. Madhukishwar and others versus State of Bihar, 1996. Impairing or nullifying enjoyment. Enjoyment of a right means to fully possess and benefit from a right or put into practice a right in one's life. That is, completely put it into practice. Impairing enjoyment, the full measure of the right. Women were prevented from being appointed to posts other than that of clerks or matrons in men's jails by a government order. In a challenge to the order, the court upheld it as hazardous duties could not be done by women and it would affect the efficiency of the administration. Mrs. Raghuban Saudagar Singh versus State of Punjab and others, 1972. Nullifying enjoyment. A woman born in Canada was registered as a Maliseet Indian. In 1970, she married a non-Indian and as a result lost her rights and status as an Indian. She lost the right to use and benefit from the land allotted to the band as well as her right to reside on the Indian Reserve. Lovelace versus Canada. Other elements of Article 1. Irrespective of marital status, male and female flight attendants on both Air India and Indian Airlines had similar job descriptions. However, their service conditions were different. According to the service regulations governing the age of retirement, male flight attendants retired at 58 years, while female flight attendants retired upon attaining the age of 35 years or on marriage if it takes place within 4 years of service or on first pregnancy, whichever occurs earlier. Air India versus Nargish Mirza, 1981. On the basis of equality of men and women, CEDAW casts a duty on the state to ensure for women the effective eradication of discrimination as well as the achievement of substantive equality. While the language on the basis of equality of men and women seems to suggest the standard has to be same as that applied to men, the underlying concept of substantive equality means the terms of reference may include standards which are completely different from the treatment meted out to women based on context. The definition of discrimination also provides a guide for assessing when the different treatment accorded to disadvantaged groups is permissible. A good framework for assessment is the following, and any action or inaction must be assessed on the basis of the extent to which it provides equality of opportunity, equality of access and benefits, equality of results. The latter requires that the state ensures the practical realization of rights. This is the obligation of results.